Hello everyone, and welcome to my presentation, Surrogacy 101 Canada, a step-by-step guide for your legal needs. I am Shirley Levitan. I am a lawyer practicing out of Toronto, Canada. I have been practicing in the area of fertility law since 1996. I know that is a very long time. I could write a book that just encompasses the changes themselves, and believe me, there have been many. I also practice family law and have been doing that since the early 90s. There is an overlap of some pretty important issues in the two areas of law, and having considerable experience in both these areas can prove very, very helpful in understanding some of the overlap and how that applies to you. So let's get on to it. Just as a general overview, if you are considering surrogacy in Canada, there are two levels of legislation to be concerned with. There's the Federal Assisted Human Reproduction Act, which became law in April of 2004. This legislation states very clearly you cannot pay a fee to a surrogate. Surrogacy itself is absolutely fine, but you cannot pay her a fee. What you can pay are her expenses incurred in connection with the surrogacy. The government came out with a list of those expenses in June of 2020, and we'll get into detail about that a little later on. In terms of parentage and the birth registration, you have to be mindful of the provincial laws. Birth registration and parentage is determined provincially in this country. Each province has its own set of laws that deal with birth registration, including in the context of using a surrogate, and parentage. So that's the other set of laws that you need to be mindful of. In terms of the price, because that is something everyone is concerned with, this is an estimate only. Please be mindful of that. If you already have frozen embryos, then the recommended budget is about $70,000 to $90,000. And that is going to be used to cover medical and legal fees, agency fees if you're using an agency, legal fees, the surrogate expenses, and then post-birth expenses to deal with things like parentage. And if you are coming from out of the country and using a surrogate in Canada, you're going to have to be mindful of the medical expenses for your newborn, because that will, for the most part, not be covered. Your surrogate's medical expenses will be under her provincial medical plan, but not the newborn if you are a non-Canadian. So we now move to the step-by-step guide, starting with the pre-embryo or embryo stage, moving to the surrogacy contract and a host of other issues, and ending up with the creation of your family. I have separated out this presentation into three main steps. Step A being pre-pregnancy, step B being during pregnancy, step C, post-pregnancy. So when you're considering surrogacy, the very first thing you really should be doing is speaking with a fertility lawyer. Not a real estate lawyer, not a commercial lawyer. You want someone who practices in the area, who has the experience, who knows the ins and outs, who can look at the situation from a perspective of both intended parents and the surrogate, and that will be very helpful to you in the negotiation of your contract, the creation of your contract, and in dealing with a host of other matters. The consultations are generally no cost. Most lawyers are happy to talk to you without charging you, to give you an overview of the landscape. The lawyer will, or at least should, provide you with an overview of the legal issues, practical information on how to manage the process, information on parentage, again, that's a provincial determination, and then issues to be considered in your surrogacy agreement. The overview of the legal issues will involve a discussion of the expenses and reimbursements with respect to the payments, the allowable payments to your surrogate, with respect to the expenses incurred in connection with her surrogacy, legal consequences, the age requirement. The surrogate has to be at least 21. If you're using a donor, he or she must be at least 18. An overview of legal parentage, and then agency issues and payment to your agency, again, if you're using one. Not all of you will. Practical information. In addition to the legal issues, these are things that you want to consider. It is a very overwhelming process. I understand that. You've been on a long road to get here, and you want someone in a position to break it down for you and also to give you practical tips. So we've discussed the budgetary issues, budgetary requirements, how to find your surrogate. Everybody wants this information and knowledge. There's really three ways. There's friend or relative, online, and using an agency. I do not recommend that you find somebody online. You don't know what you're going to get. There's no vetting system. There's nothing to assure you or ensure that this is going to be a legitimate situation. I think it's a potential recipe for disaster, and I would recommend that you avoid that. There are some very good agencies in this country. Some will manage the expenses to the surrogate for you, some will not. That choice is something you should discuss with your lawyer. When do you look for a surrogate? Do you wait until you've created embryos, or do you start the search before? I would say that more and more often, people are waiting until their embryos are created. The reason for that is it can take time to create your embryos, and you don't always know how much time. And because there are typically more intended parents than there are surrogates, the women who are going to make themselves available to be surrogates are not necessarily going to want to be chosen and then be in a position of having to wait a number of months for the embryos to be created. So my recommendation would be to have your embryos created and then start the search for your surrogate, or at least maybe start very close to the embryos being created. When you're looking for your surrogate, you want to consider her own situation, her own family, ensure her partner is supportive. And what are the needs of her family? Does she have young children? What are her energy needs? What are her time needs? What is her job situation? These are all things you're going to want to discuss with your lawyer and even with the agency. The timing of the agreement. Do you get it done before or after the medical assessment? There's pros and cons of each, and this is again something to discuss with your lawyer in more detail. In terms of communicating with your surrogate, what's the best way? Are you going to use video, chat, text? I know that maybe the suggestion of using a phone, maybe that's outdated now. I don't know, but that's also possible. That's something to think about. The clinic choice and communications with your clinic. Which agency do you choose? You know, it's best, of course, to speak to several, find out what their models are, what they offer you, the feeling that you get from them. Again, some of them will manage your expenses, some of them will not. And then another thing to consider is counseling. That is something most clinics are going to require, that your surrogate have at least one session with a counselor, just to ensure that this is the right fit, and maybe to look for some red flags. That's going to be something else to consider in your budget. In terms of parentage, you should be discussing with your lawyer, again, the provincial parentage regime. Keep in mind that where your surrogate gives birth is going to be the province in which the birth is registered. So if you live in Ontario and your surrogate is in Alberta and she has the baby in Alberta, that's the birth registration law that is going to govern your parentage. You want to consider that there are certain provinces whose birth registrations do not necessarily meet up with surrogacy-friendly parentage. So for example, Prince Edward Island and Quebec are what we call adoption jurisdictions. That's something to get into in more detail with your lawyer. But what that means in English is, unless the woman you find to assist you and who may live in one of these provinces is prepared to have the baby in another province, For example, in Quebec, if you find someone who lives close to Ontario and she's ready, able, and willing to have the baby if you find someone who lives in Quebec and she's ready, willing, and able to have the baby in Ontario, then you can consider that. So while these provinces are not necessarily the first ones you may consider, the first ones that will come to mind with respect to where you're going to pursue the surrogacy, don't automatically rule them out, because there may be a way to work with them. Again, if she lives in PEI and she is prepared to give birth in Nova Scotia or New Brunswick, that may work for you. Other provinces, for example, Alberta, require a genetic connection between the intended parents and the baby. So if you are using donated embryos or embryos created with donor sperm and donor egg, you can't have a surrogate in Alberta who's going to give birth in Alberta, because Alberta's laws require that there be a genetic connection between the intended parents and the child. You're going to want to discuss the cost of the process with your lawyer. And then if you are, again, coming from outside Canada, the issue of medical insurance for your newborn is something to very seriously consider. What should you consider for your agreement? Lots and lots of things to consider. It can feel very overwhelming, but it can be broken down, no problem. Some of the more salient issues: number of embryos to transfer at a time. How many transfers over the length of the contract period? What is the length of the contract period? 1 year, 18 months, 24 months? How many fetuses is the surrogate prepared to carry? What is the plan if there's a medical issue or bed rest is required? This is a very important one. How do you feel about terminating the pregnancy if there's an unfortunate genetic testing result of the embryo? How do you feel about abortion and selective reduction? You want to ensure, to the extent that it's possible, that you and your surrogate are on the same page about this. Other things that you're going to want to consider: what about her medical care? Obstetrician, midwife, what do you prefer? What does she prefer? Are there issues with respect to food restrictions, activity restrictions? Who can or may attend at the birth and at medical appointments? What about confidentiality issues? Are you okay with her posting things online about her journey? What about the future relationship of the surrogate and the child, if any? Then what if the intended parents divorce or pass away? The issue of the expenses can get quite complicated and quite heated. In terms of details, they are typically set out in the agreement. We typically put a cap. Most agreements will have a maximum of expenses, and then they may have a category of expenses that are paid separate from or in addition to the cap. So keep in mind that the federal legislation prohibits payment of a fee. The expenses require being accompanied by a receipt. Loss of work-related income during the pregnancy can be had provided a physician certifies in writing that continuing to work may pose a risk to either the surrogate or to that of the fetus. Unfortunately, the government did forget about a couple of things, like maternity leave, wage top-up, and so they released, at the same time they released a list of expenses, which was June of 2020, another document called a guidance document, which basically helps to explain how the regulations work, how you need to keep track of the expenses, and also provides very specifically that the expense list is not exhaustive, which is very helpful, because the more general the expense list is, it means the more certain it is that your surrogate is not going to be out of pocket, because you certainly don't want that. There's no minimum or maximum amount that you can pay to reimburse your surrogate. As long as the expense is related to the surrogacy and there is a receipt or the required medical certification, then it's fine. One thing to keep in mind is payment of anticipated expenses is not permissible under this legislation. And there are some options that you may be able to pursue to help deal with that. and again, something to discuss in more detail with your lawyer. The guidance document also makes it very clear that you can reimburse the surrogate her maternity wage top-up, but a doctor does need to sign off on that, certifying that she needs the leave in order to protect her health. Keep in mind, this guidance document is not law. However, it was released at the same time that the list of expenses was released by Health Canada. Personally, I attach a copy of the guidance document as well as the regulations as schedules to my agreement, just to add a little bit more emphasis that this document did come from the government, and this is guidance from the government itself. To get a little bit more specific about some of the expenses you're looking at, her medications, clinic fees, all her travel, both inter and intra-city, the counseling, her legal fees. Legal fees for her independent legal advice are going to range between about $1,700 to about $2,100, $2,200 plus tax. The lawyer for the intended parents, that range is, I would say, between about $3,200, $3,300 to $3,900, $4,000 plus tax. The legislation allows for care of her children, even pets. The government threw that in there. If she is prescribed bed rest and she needs extra help with this, additional home care, midwife or doula, groceries, excluding non-food items. So remember, non-food items are not included. This is to support a healthy pregnancy. This is just not her general day-to-day groceries. Various types of insurance, life being very important, those premiums, maternity clothing, telecommunications. This would be over and above her regular monthly fee that she has to incur in order to support the pregnancy and the surrogacy. Then there's another catch-all category that needs to be recommended in writing by a person authorized under the laws of the particular province to assess, monitor, and provide health care to a woman during her pregnancy, delivery, or the postpartum period. So this would include any products or services recommended in writing by such a person. So this doesn't have to be a physician recommendation. This can be a midwife or a nurse recommendation, for example. And that would include things like fitness, yoga, acupuncture, chiropractor, various other pregnancy supports. It is a catch-all category, and it can be very helpful. So after you've had an introduction and an overview with your fertility lawyer, you now have to move on and decide, if you haven't already, which clinic, agency, counselor, and lawyer to use. Once you've done that, you're going to want to arrange your finances and budget for the journey. The last thing you need is to worry about money down the road. Once you find your surrogate, remember we're still in the pre-pregnancy step, you're going to organize the communications preferences with your surrogate. Again, what makes sense for you and for her? Texting, video, FaceTime, whatever works. You're going to contact your lawyer about the surrogacy agreement. You're going to confirm the timing with your clinic of the medical screening and the timing of the embryo transfer. As much as my mother would love if I were actually a physician, I'm not. And these are definite issues that you need to clear with and discuss with your medical people. And also confirm the counseling appointments. The way it works practically is most clinics will require a letter from your lawyer confirming that the surrogacy agreement is final and signed before they will undertake the embryo transfer. In fact, more and more clinics now want that letter before they will even start the surrogate on her hormone regime. So that could reduce the timeline you think you have once you think you're ready to go and when the agreement should be drafted. We've now implanted the embryo, well, not me personally, but your doctor, and she's pregnant. So this is very exciting, and here are some tips and some hints to help you out with step B during the pregnancy. Follow the agreed upon communication protocol with your surrogate. track the receipts and ensure that she's reimbursed her expenses on a timely basis so she isn't out of pocket. Whether your agency does it or you do it, this is important. You don't want her out of pocket. That would be very uncomfortable. In terms of managing the expenses and the receipts, it's not as daunting as people might think it is. There are a lot of apps out there. A lot of my clients who manage their own expenses use Excel spreadsheets. There are forms your lawyer can give you to help you with this. It's really not as onerous as you might think there is, as you might think it is. And I understand, of course, some of you may have or may prefer agencies that will do this for you. One thing to keep in mind is the receipts and the records have to be kept for at least 6 years. That's a requirement under the Assisted Human Reproduction Act. Keep a calendar to ensure important dates are highlighted. Her ultrasounds, medical tests, her other doctor's appointments, and ensure you contact her before and after each one to give her encouragement. You want to make sure that she feels supported and appreciated, and check in with your surrogate. I mean, not so much that she feels, that you're stalking her, but certainly regularly to ensure that she feels that you're supporting her and appreciating her, and to follow up with her well-being and how she's doing. This is a very collaborative relationship between you and your surrogate. You are very vulnerable. You are enlisting another human being to carry your child after a very long journey to get there. That is an extremely vulnerable place to be. You want to be respected, and you don't want to be taken advantage of. Your surrogate has made herself available to assist you realize that dream, and so she also wants to be respected. And it's really a mutual, collaborative, and mutual respectful and trusting relationship that will really leave you and your surrogate feeling most comfortable. In the last 2 months of the pregnancy, I would say month 6, month 7 at the latest, contact your lawyer and start to think about and talk about the post-birth parentage process. Because moving into step C, depending on which province the baby is born in, there may be a court application required. It may just be a couple of documents that need to be filled out. If there's an administrative birth registration filing, for example, Ontario and British Columbia offer that particular option if certain criteria are met with respect to the underlying agreement, and you want to get on that. Often, your lawyer will send a letter to the hospital or to the midwife, putting them on notice that the birth is pending and maybe setting out a birth plan. Although keep in mind that if you are having the baby at a hospital, regardless of what your lawyer puts in that letter, the hospital will have its own protocol that it's, for the most part, going to follow. One thing to keep in mind, if the baby is born in Ontario, you won't get an OHIP number from the hospital. There's another process that you can discuss with your lawyer who will and should help you with that. So that pretty well covers it. The one other main question that a lot of people ask, I would say with very few, if any exceptions, every intended parent who's ever contacted me over all these decades, at some point, what if she keeps the baby? What if my surrogate wants to keep the baby? What if she keeps the baby? I can tell you, in my experience, that has never happened. She doesn't really want the baby. She has her own family. She has her own children. She's done this to help you realize your dream. We're not in the States. It's a very different regime in the States. Surrogacy is governed state by state there, and people sort of state hop and state choose depending on what's legal there. And many of those unfortunate stories you read in the paper are not coming out of Canada, they're coming out of other countries. So rest assured, that's likely not going to happen. And if it does happen, then there's probably, I would say, pretty close to zero chance of her being in a position to legally keep that baby. So we're coming to the end. I've kept you, I think, now for enough of your day. I hope that you have found this helpful and informative. And if you have any questions that you want answered or clarification, please don't hesitate to give me a call or shoot me an email, shirley@familyandfertilitylaw.ca. I am happy to help you, and I want to thank you for joining me, and have a great rest of the day. Okay? Take care.